I'm joined by attorney Tom Kokonowski. He's a former prosecutor. He's been working as a criminal defense attorney since 1995. Tom, as I'm sure you know, we've been talking about stand your ground laws in Florida. Most people first heard of stand your ground based on the George Zimmerman case, in which he was eventually acquitted of the second-degree murder of Trayvon Martin. There's now a new case in Florida that's bringing stand your ground back up, which is the case of Marissa Alexander, who fired a warning shot into a wall in an act of self-defense, and she was actually blocked from using stand your ground, even though she was she feared for her life, quite literally, based on her husband's actions. Now there's been a new trial granted after she was convicted to serve 20 years in prison. Let's first start with this particular trial. Why is there now a new trial?
There is a new trial very specifically because the appeals court, there was an appeal taken by Ms. Alexander and her legal team, as there usually is after a trial of this magnitude and certainly that number of years sentence. But obviously when there is error by the judge, which the defendant and her lawyers think happened, and the appeals court in Florida found, in fact, that there was a big error made by the judge with regard to the way the judge instructed the jury about standard self-defense. And the appeals court found that that error was enough to grant Ms. Alexander a new trial.
So let's explore exactly what those jury instructions were. What were the jury instructions that were given with regard to burden of proof in self-defense, and what should they have been according to the law?
Well, that's exactly what the issue was. What Ms. Alexander's legal team argued, and the appeals court agreed with, was that the way that the judge worded the instruction with regard to sort of the overall self-defense, and specifically with regard to proving who has to prove what. The judge in the jury trial instructed the jury essentially, and I have it here to read, but essentially he shifted the burden. The judge shifted the burden, which never happens, but the judge shifted the burden to the defendant, specifically with regard to use of force and saying that it was the defendant's duty. Not sure if the judge intended for it to happen, but the way that it was worded, it essentially said that it was the defendant's burden to prove beyond a reasonable doubt that the named victim in the case was committing or was about to commit an aggravated assault and battery, and the appeals court said no, that's burden shifting, and that is not how the jury should have been instructed.
What's fascinating about this is that throughout the George Zimmerman trial, there was so much discussion about how, since it was, in a sense, self-defense is, in a sense, an affirmative defense, where you're not denying that the act took place, but you're saying there was justification for that act. And all
Correct.
throughout the Zimmerman trial, there was discussion that, hold on a second, shouldn't it be George Zimmerman's defense team who has to prove that he did fear for his life? And that was not how the law was written, and therefore it led to the acquittal of George Zimmerman. In this case, you would assume, of course, that the burden would be the same. It's the same state. It's the same type of case. However, it was not the instruction that was given by the judge. So then we get to the question, this was the right decision. I think we all agree, Tom. We get to this question of stand your ground and or self-defense in general. Do we have a problem where, like the war on drugs, like so many other areas of law, they are selectively and disproportionately applied to give African Americans and minorities a more difficult time and used to exculpate, in many cases, white defendants?
The question is, do we have a problem there?
Yes.
I mean, obviously, I think that is a problem if that is what's happening. I think that, you know, as a criminal defense lawyer, I find it hard to not have to say we have to take each individual case on a case-by-case basis. I don't know that answer overall. Obviously, it's a problem if it's happening, but One of the reasons I say case by case basis is, researching to prepare for this interview, I found that there are facts that I didn't know about simply from sort of casually looking at the media and how the media reported things. And I believe you opened this segment with somebody was not allowed to use stand your ground. I think you said that Ms. Alexander was not allowed to use stand your ground. And I've heard that said before, and I'm not sure exactly what people think that means.
Well, I think there is a misunderstanding about that, and it did actually come up. And interestingly enough, during the Zimmerman case, it came up during the questioning of the witness who was Mr. Zimmerman's former instructor in some coursework. And it was compelling because the content of the interview shifted to actually discussing the merits of stand your ground and the castle doctrine with the witness, which was incredible. So let's explore that a little bit. Inform the audience about what does it mean to invoke stand your ground in the context of a Florida case.
Well, one of the very interesting distinctions between these two cases, as I read them, a lot of the way cases turn out has to do with the strategy that the defense uses in the case. And as I read the statute, and as I read actually the appellate court's decision in Alexander, and as I watched the colloquy of Mr. Zimmerman with regard to immunity, there are two parts essentially to this stand your ground statute that I didn't know about until I did the research on this. The first part is requesting immunity as a result of stand your ground, meaning that you have the right as a defendant down in Florida to prove to a judge alone.
Okay, so we lost Tom there. Tom had very nice to take time out literally in court to speak with us, and it appears that the last-minute internet connection that we got with him did not hold. So in any case, we are glad that Marissa Alexander is getting a new trial here. It is absolutely the correct thing, in spite of all of the other issues regarding the ability to invoke stand your ground or not. The fact that the jury was given flat out incorrect instructions based on the writing of the law makes absolutely no sense. We're, of course, going to cover the new trial. We'll take a break. We will follow up. And, of course, we'll have more stories and your voicemails right after this.